We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. The Declaration of Independence begins with some truly inspirational words, yet almost ironically, they were penned by Thomas Jefferson, a slave owner. Slavery was America's founding contradiction, a disease that festered at the heart of American society, seeping into every level of government and the economy in open defiance of the values of liberty and equality the nation was founded on. Then one day, that contradiction was gone, abolished by the 13th Amendment. Today, the 13th Amendment is usually just remembered as the one that abolished slavery, but was originally conceived as representing something much greater. Not just the end of slavery, but an affirmation of the freedom promised by the Declaration and a commitment to enforcing that freedom. Tragically, this greater purpose was gradually discarded and forgotten, with lasting consequences for American history. Despite the Declaration's soaring rhetoric, slavery soon found its way into the Constitution in the form of a trio of compromises meant to placate the southern states. The 3/5 compromise made it so slaves were counted as 3/5 of a person when counting each state's population, giving the South, with its large slave population, more representation in Congress. The Slave Importation Clause forbade Congress from interfering with the importation of slaves until 1808. Finally, the Fugitive Slave Clause made it so slaves who escaped to another state would be returned to their masters. As the country expanded westward, the slavery debate flared up again over whether the institution would be allowed in the new territories after Missouri applied for statehood as a slave state. In the Missouri Compromise, Congress allowed Missouri to enter the Union alongside Maine, a free state, and banned slavery in all the remaining territories above this line. Then, America acquired a ton of new land below that line after the Mexican-American War, renewing the debate. The ensuing Compromise of 1850 ultimately left open the question of slavery's expansion into the territories and included the Fugitive Slave Act, a law meant to strictly enforce the Fugitive Slave Clause. Just a few years later, Congress passed the Kansas-Nebraska Act, which allowed the Kansas and Nebraska territories to vote on whether or not to allow slavery, despite both being above the Missouri Compromise line. Pro- and anti-slavery settlers flooded Kansas to tilt the vote in their favor, and the territory soon became a war zone. Then, the Supreme Court handed down its infamous Dred Scott ruling, finding that all African Americans, enslaved or not, could never be U.S. citizens, and that Congress had no power whatsoever to stop slavery from expanding into the territories. The decision, authored by Chief Justice Roger Taney, was riddled with legal and historical inaccuracies and only helped inflame the growing crisis. Throughout these decades, Northerners had grown increasingly hostile to the institution of slavery, and in the aftermath of the Kansas-Nebraska Act, a variety of anti-slavery groups coalesced into the Republican Party. The victory of Republican presidential candidate Abraham Lincoln in the 1860 election horrified the South. Believing a Republican in the White House posed an existential threat to slavery's existence, 11 Southern states seceded, beginning the Civil War. At first, Lincoln and most Republicans did not support abolition, instead preferring to merely confine slavery to the states where it already existed. They were even willing to accept a proposed amendment that would permanently forbid Congress from interfering with slavery in any state. Over the course of the war, though, this view gradually changed, and on January 1, 1863, Lincoln issued the Emancipation Proclamation, freeing every slave in the rebellious states. This represented a major transformation in the war, which had begun as an effort to preserve the Union, but would now end as a campaign to end slavery as well. However, the proclamation had been issued using Lincoln's wartime powers as commander-in-chief, so it was unclear whether emancipation could remain in effect once the war was over. It was also unclear if Congress had the power to enact emancipation with legislation. Given these considerations, in late 1863, Congressman James Ashley proposed the first version of the constitutional amendment that would finally and completely abolish slavery. The final version of the amendment was hammered out by Senator Lyman Trumbull and his Judiciary Committee, and it had two sections. The first contained a prohibition against slavery and other forms of involuntary servitude except as punishment for a crime. This language was modeled after the Northwest Ordinance of 1787, which had forbidden slavery in the Northwest Territory. They used the ordinance as inspiration because of its familiarity, and because Republicans really liked pointing to it as evidence of the founding generation's alleged hostility to slavery. The second section incorporated a proposal from Congressman James Wilson, and it granted Congress the power to enforce the first section. Sounds simple enough, but this was a big deal, because this would be the first time since the ratification of the Constitution that the federal government had gained power. The Bill of Rights had restricted the government from infringing on various freedoms, but this new amendment would allow it to actively protect freedom, both from states and private actors. Support was somewhat limited at first, with some being wary of making such an immediate and far-reaching change, but the war had a way of changing people's minds. Slavery had been the wedge that drove apart the North and South, culminating in the horrific bloodshed of the Civil War. If victory was to mean anything, slavery had to go, lest the sectional conflict return once the war was over. Furthermore, hardly anyone wanted slave owners' interests to dictate national policy anymore, like we saw with the many compromises. Finally, for many people, it was simply time to end the contradiction between liberty and slavery to fulfill the promise of America's founding. The proposed amendment was passed by the Senate on April 8, 1864, and Lincoln publicly embraced the measure in the lead-up to the elections that November. It wasn't all smooth sailing, though. In June, the House of Representatives rejected the amendment, coming up 13 votes short of the needed two-thirds majority. The vote largely split along party lines. Republicans backed the proposal, but most Democrats were against it. During debates over the amendment, many Republicans had championed the idea that it would both abolish the institution of slavery and empower Congress to legislate against all of its incidents. Incidents of slavery included any attempt to deny freedmen the equal enjoyment of rights that all citizens were entitled to. This was why Section 2 had been added to the amendment. Section 1 gave freedom to the slaves. Section 2 enabled Congress to make that freedom real. The possibility of equal rights for black people motivated many Democrats to oppose the bill, alongside the belief that slavery was a state issue. After Lincoln won re-election, he began putting significant pressure on the-fence Democrats, especially those who had just lost re-election and were now free to break the party line and vote their conscience. Thanks to these efforts, the House passed the amendment on January 31, 1865, sending it to the states for ratification. 3/4 of the states were needed for the amendment to become law, but some Republicans believed the rebel states should not be included in that total, which would make it much easier to ratify the amendment. Otherwise, the only way to reach the requisite number of states would be to secure the support of at least some of the states which had just seceded and fought a war to protect slavery. Lincoln disagreed, believing excluding the South from the ratification process would only open up the amendment to future questions of its legality, and his opinion won out. Unfortunately, the great emancipator would not live to see emancipation enshrined in the Constitution, as he was assassinated on April 14th, with only 21 states having ratified the amendment. Upon Lincoln's death, Vice President Andrew Johnson succeeded to the presidency. Johnson, a Tennessean who'd remained loyal to the Union, urged the South to accept the amendment, helping to finally push it over the line. On December 18th, the proposal was formally ratified as the 13th Amendment to the Constitution, the first amendment in 61 years. Slavery was finally gone, and every slave was now finally free. The work wasn't over just yet, though. Almost immediately after ratification, Southern states passed black codes that basically resurrected slavery in all but name. These codes heavily restricted the freedmen's rights and included laws that were almost impossible not to break. For example, one Louisiana law required freedmen to own a home, but another banned them from buying property. As punishment for breaking ridiculous laws like these, convicted freedmen would be used as prison slaves, exploiting the 13th Amendment's exemption for prison labor. Southern states also adopted new apprenticeship laws that allowed judges to separate black children from their families so they could work as apprentices for their former owners. Oftentimes, the South's new laws were not racially discriminatory on their face, but they always targeted the freedmen in effect or through selective enforcement. It was in this context that Trumbull introduced what would become the first civil rights law in American history. Trumbull's proposal conferred citizenship on everyone born in the United States, thus extending citizenship to the freedmen, and declared that all citizens were entitled to certain rights. This list included the right to make contracts, sue, testify at court, and buy and sell property. It also protected the right to have the equal benefit of all laws as they were enjoyed by whites. If someone's rights were violated by a state court, they'd be able to transfer their case to a federal court. Trumbull believed Congress had the authority to pass a bill like this through Section 2 of the 13th Amendment. In his mind, the amendment he had played a key role in authoring did not just destroy slavery, but also all of its incidents, which civil rights violations were a clear example of. Abolition alone was just a mere declaration of principle that was ultimately meaningless. Freedom from bondage was hollow if you had no power to enjoy it. Thus, his bill was needed to give effect to the freedom created by the 13th Amendment. However, when Congress passed Trumbull's proposal, it was vetoed by Johnson. Despite initial hopes that he'd lead an aggressive reconstruction of Southern society, the president was perfectly happy with the black codes and unwilling to do much more than abolish slavery in name only. Nonetheless, Republicans in Congress mustered a two-thirds majority to override the veto, passing the Civil Rights Act on April 9, 1866. It wasn't long before the new law was challenged in court. The case revolved around Nancy Talbot, whose home had been burglarized. She was black and the burglar was white, and a Kentucky law forbade black witnesses from testifying against white defendants. Because of this, the case was moved to a federal court, in accordance with the Civil Rights Act, but the burglar challenged the law as exceeding Congress's power. The judge presiding over the case was Supreme Court Justice Noah Swain. Back then, individual justices traveled around the country and heard cases in the lower courts, a practice called riding circuit. Swain held that the abolition of slavery was a phantom of delusion if Congress had no power to enforce the rights that came with freedom. Infringements on these rights were badges of slavery that Congress had broad discretion to legislate against because of Section 2. With the Civil Rights Act, Congress decided that bans on the right to testify were a badge of slavery, which was reasonable since slaves had been banned from testifying. As such, the act was valid, and the prosecution of the burglar could move forward in federal court so Talbot could testify. Swain's decision was bolstered the next year by Chief Justice Salmon Chase while he was riding circuit in Maryland. Chase heard the case of Elizabeth Turner, a black child taken from her family and given to their former master through Maryland's apprenticeship laws. Under these laws, black apprentices were literally just slaves, while white apprentices were actually apprentices. Chase decided this was unacceptable because Maryland was obviously just trying to reinstate slavery. The state's laws also violated the Civil Rights Act by discriminating between black and white citizens, denying the former equality under the law. These early decisions seemed to signal the judiciary's embrace of a broad meaning of freedom under the 13th Amendment and Congress's robust role in protecting it. That understanding was put to the test at the Supreme Court in 1872. John Blyew and his friend George Kennard had murdered 4 members of a black family. One of the victims, Richard Foster, had lived long enough to give a sworn statement of what happened. His sister Laura survived and testified that Blyew and Kennard were the killers. Because all of this happened in Kentucky, which still had its law against black witnesses, the case was moved to federal court, where Blyew and Kennard were convicted and sentenced to death. Then the Supreme Court intervened and overturned the convictions in Blyew v. United States. The court reasoned that the Civil Rights Act only protected the right of black defendants and plaintiffs to testify. Richard and Laura were just witnesses, so they weren't covered. This meant nobody's rights had been violated, so the case shouldn't have been moved out of state court. Swain and a certain Joseph Bradley dissented, criticizing the majority for its artificially narrow reading of the act. The 13th Amendment enabled Congress to ban badges of slavery. This was evident in the amendment structure. Section 2 would be redundant if it only allowed Congress to prohibit slavery, which Section 1 already does. Therefore, it was clearly intended to enforce the freedoms that came with abolition. Using this power, Congress decided that the right to testify was the fundamental civil right of all citizens. Any attempt to deny this imposed a badge of slavery in violation of the law. They also pointed out that the majority decision incentivized violence against the freedmen, since victims now had no way of testifying against their attackers. The 13th Amendment's next major outing at the Supreme Court came in 1883. Congress had passed another Civil Rights Act in 1875, this time banning racial discrimination in many public facilities, but the law's constitutionality was challenged in the civil rights cases. The government claimed the law was valid thanks to both the 13th and 14th Amendments, the former because it empowered Congress to fight intrusions on freedom, and the latter because it guaranteed equal protection under the law. The Supreme Court, however, disagreed in an opinion authored by Bradley, who'd had a change of heart on civil rights. The court dispatched the 14th Amendment argument by holding that it only applied to states, while the 1875 Act regulated businesses. As for the 13th Amendment, the court acknowledged that it allowed Congress to fight all badges and incidents of slavery to enforce the freedom created by abolition. It's just that this freedom did not include access to public facilities. If it did, that would be forced social integration, which the government had no power to do. One justice dissented from this ruling, John Marshall Harlan. Harlan was a Kentuckian who'd once opposed the 13th and 14th Amendments and even defended the Kentucky law from earlier at the Supreme Court as the state's Attorney General. However, his views on civil rights had shifted in response to widespread bloodshed and oppression in the post-war South. Writing his dissent with the inkstand Roger Taney had used to pen Dred Scott, Harlan came to the defense of a broad meaning of freedom created by the 13th Amendment. He pointed out the hypocrisy of the court having provided expansive protections for the rights of slave owners before the Civil War, with decisions like those that upheld the Fugitive Slave Act of 1850 and the Dred Scott ruling. Now, the court was seemingly arbitrarily deciding that the 13th and 14th Amendments, which had been passed specifically to empower Congress to protect the rights of African Americans, were somehow not enough. On top of that, he pointed out that slavery as an institution had been built on Africans' supposedly inherent racial inferiority and the deprivation of all of their rights, including access to otherwise public facilities and freedom of movement. Abolition meant the destruction of all of these discriminatory barriers to the freedom enjoyed by all people. Congress must have the power to target these badges of slavery, so those badges identified and forbidden by the Civil Rights Act of 1875 were a perfectly constitutional exercise of Congress's authority to enforce the 13th Amendment. He also upheld the act under the 14th Amendment. Public facilities were chartered by the public through their state governments for the public's enjoyment. African Americans were part of the public, so they could not be denied this. Since they were, Congress could legislate against it. With federal enforcement of civil rights falling apart, Louisiana passed the Separate Car Act in 1890, mandating segregation on trains. Homer Plessy challenged the law after he was blocked from getting a first-class seat in a train's whites-only car, and his case made its way to the Supreme Court in 1896. Famously, Plessy argued that the Separate Car Act violated the 14th Amendment's promise of equal protection, but the Supreme Court disagreed, holding that segregation was permissible under the guise of separate but equal. Less well known is the fact that Plessy also invoked the 13th Amendment. His argument went that segregation resurrected the racial hierarchy imposed by slavery and resubjected African Americans to a position of inferiority. The Supreme Court disagreed with this too, of course, deciding the amendment only prohibited the literal definition of slavery, meaning the forceful control of another person's labor. Segregation was thus an entirely different issue. Even if it was covered, the court decided Plessy was wrong to think that it implied racial inferiority. With this, the court completely abandoned the whole badges or incidents of slavery thing, finding that abolition did not create a right to live in freedom. The court even explicitly said they didn't understand why Plessy devoted so much attention to his 13th Amendment argument. Harlan understood, though, alone in dissent once again. Like before, Harlan asserted that the 13th Amendment did more than abolish slavery as an institution. Abolition had eliminated every distinction between slaves and any other citizen. All Americans were now entitled to the same freedom, with all the rights that entailed. That freedom necessarily included the right to be free from laws that relegated people to an inferior subject class. Louisiana had infringed on this right with the Separate Car Act because it was an obvious attempt at restricting African Americans' freedom. The arbitrary separation of races reaffirmed the notion from before abolition that African Americans only had the rights the white majority was willing to give them, and that these rights could easily be taken away. Harlan declared that the Constitution was colorblind and did not tolerate the idea of a racial hierarchy where some races enjoyed more rights than others. He called out the thin disguise of separate but equal, arguing that separation clearly deprived African Americans of equality. For these reasons, segregation was an unconstitutional badge of slavery. Nonetheless, the majority's ruling paved the way for a wave of new segregationist laws that held for over half a century. In his dissent, Harlan had prophesied that Plessy v. Ferguson would be remembered in the same light as Dred Scott. History has certainly proven him right. The dismantling of the 13th Amendment wasn't over just yet. In Arkansas, a white mob attacked 8 black workers and drove them from their jobs because they were black, forcing them to break labor contracts. Federal prosecutors charged members of the mob with breaking the Enforcement Act, which had been passed after the Civil War and criminalized conspiracies to violate rights secured by the Constitution or by federal law. Remember, the Civil Rights Act of 1866 had specifically protected the right to contract. 3 members of the mob were convicted, they appealed, and the Supreme Court heard their case, Hodges v. United States, in 1906. Unsurprisingly, the court overturned the convictions, holding once more that the 13th Amendment only banned the use of forced labor and did not secure any kind of freedom from the restrictions that characterized slavery. It did not matter that the crime had been race-based or that a federally protected right was violated. These things were just too far removed from the concept of forced labor. Although they were characteristics of slavery, lots of things were, so that wasn't a good enough reason. Yet again, Harlan dissented, this time joined by one other justice. He reiterated that the 13th Amendment's first section prohibited slavery, and the second allowed Congress to prohibit its badges. Even the majority decision in the civil rights cases had recognized this. Slaves had no right to contract. Congress recognized this and enshrined the right with the Civil Rights Act, so any infringement on it imposed a badge of slavery. Moreover, freedom from slavery, at the very least, meant a right to live and work how you wanted. The defendants had violently deprived the victims of the rights secured to them by the 13th Amendment and the laws meant to enforce it, so their convictions were valid. Harlan died 5 years after Hodges was decided, his views having never found much acceptance on the court in his lifetime. However, he's been remembered as the great dissenter for his fiery dissents in civil rights cases and many others. His opinions would provide inspiration and ammunition for future generations in the fight for civil rights. That fight kicked into high gear with the Supreme Court's 1954 decision in Brown v. Board of Education that overturned Plessy v. Ferguson on the grounds that separate was inherently unequal. Notably, the court decided Brown using the 14th Amendment, not the 13th. Nonetheless, Brown set off a series of landmark civil rights cases that eventually led the court to revisit it. Joseph Lee Jones and his wife Barbara Jo wanted to buy a house they liked in Missouri, but the developer, Alfred H. Mayer Company, refused to sell it to them explicitly and exclusively because Joseph was black. The couple sued, claiming the company had violated the right to buy property under the Civil Rights Act of 1866, and the Supreme Court took up Jones v. Alfred H. Mayer Company in 1968. In siding with the Joneses, the court finally embraced the broad meaning of freedom intended by the 13th Amendment. It abolished both slavery and its badges, and with Section 2 gave Congress the power to identify and forbid these badges. Congress had done just that with the Civil Rights Act of 1866, identifying restraints on the right to buy or sell property as an unconstitutional badge. This was reasonable, since these restrictions burdened a fundamental right to the enjoyment of freedom. More than that, slavery had been replaced by the Black Codes, and the Black Codes were replaced by segregation, making segregation a relic of slavery. The court cited the fact that many congressmen had helped pass both the amendment and the Civil Rights Act, so they must have thought the latter was a valid exercise of the powers given by the former. This was especially true since the amendment's author was also the one who introduced the Civil Rights Act. Trumbull's declaration that his amendment made slaves free and his bill gave effect to that freedom was clear evidence that the 13th Amendment was meant to do more than just abolish slavery. If this wasn't the case, then the amendment made a promise the nation cannot keep. The Jones precedent has stuck around ever since and been reaffirmed in a few noteworthy cases. Griffin v. Breckinridge in 1971 involved 2 black men who'd been attacked in Mississippi by 2 white men who incorrectly believed they were civil rights workers. Using one of the enforcement acts, the black men sued their assailants for compensation, alleging that several of their rights had been violated. Based on the precedent from Jones, the Supreme Court upheld the constitutionality of the suit since Congress had decided with the law that preventing the exercise of rights was a badge of slavery, even if the violation was carried out by private actors. In another case, Runyon v. McCrary, the Jones precedent was used to desegregate private schools. Brown v. Board of Education had only ordered the integration of public schools since the case was decided with the 14th Amendment, which only applies to state actors. Many states then tried to prop up whites-only private schools instead to avoid integrating. One private school in Virginia was sued by a group of parents who alleged the school's total exclusion of non-white applicants violated the Civil Rights Act of 1866. In 1976, the Supreme Court agreed and held that the policy infringed on the right to contract. Nevertheless, the 13th Amendment has rarely been invoked since. The idea that it provided a broader guarantee of freedom fell out of fashion again with the end of the civil rights movement. Instead, civil rights cases usually revolve around the 14th Amendment or the Commerce Clause, which Congress used to pass multiple civil rights laws as an extension of its power to broadly regulate commerce. The three cases I've mentioned have largely been cast aside, and the possibility of reviving the full scope of the 13th Amendment was never entirely realized. The Declaration of Independence was a visionary document, espousing high ideals like equality and liberty, yet burdened by a glaring hypocrisy: slavery. This founding contradiction gradually ripped the nation apart. As Lincoln put it, the nation could not endure half slave and half free, and with the Civil War, it was forced to choose. Abolition was the ultimate triumph of freedom, meant to usher in a new age where all Americans could enjoy the promises of the Declaration. In the minds of its authors, the 13th Amendment did more than just end slavery, because freedom is more than the mere state of not wearing chains. Moreover, freedom is not a one-time thing, but a lasting commitment to upholding and defending it. The 13th Amendment isn't just the one that abolished slavery. It's the one that finally and fully committed this country to the realization of the ideals it was founded upon. Although history has consistently underappreciated and sought to dismantle the freedom the amendment created, its promise should remain as true today as it was in 1865. That's why I believe the 13th Amendment to the Constitution is the most underrated amendment.